Let's discuss agreement in restraint of trade. Agreement in restraint of trade is void under Section 27 of the Act. According to Section 27, every agreement by which anyone is restrained from exercising a lawful profession, trade, or business of any kind is to that extent void. An agreement by which any person is restrained from carrying a trade or practicing a lawful profession or exercising a business of any kind is is expressly void agreement. Such an agreement violates the constitutional right of a person. In other words, any agreement that prohibits any person from carrying or exercising his trade, business, or profession in return for some consideration is void. A contract in restraint of trade is one which restricts a person from exercising his trade or profession. It is in the interest of community at large that every individual should be at liberty to engage himself in any trade, profession, or business and use his skill and intelligence to the best of his capacity, consistent with the good of the community. Therefore, any agreement prohibiting a person from trading or carrying on business or profession in manner he likes or whenever he likes, an agreement with the other party will be called an agreement in restraint of trade. Therefore, those agreements which restrict such freedom are opposed to public policy and are expressly declared void. The general principle is same in both India and England that all restraint of trade in India and in England that all restraint of trade, whether total or partial, are void. The only difference is that in England a restriction will be valid if it is reasonable. This was declared in the famous case of Northernfelt versus Maxim Northernfelt Gun Company by the House of Lords, that the test is not whether the restraint is general or partial, but whether the restraint is reasonable. So the reasonable in the interest of person for whose benefit it is made, and reasonable in the interest of the community, and if it is reasonable, in that case it is valid in England. So let us discuss the case of Northernfelt versus Maxim Northernfelt Gun Company's case. Mr. Northernfelt, a manufacturer or inventor of guns and armaments, he sold the business to the Maxim Northernfelt. He entered into a restrictive covenant. While entering into an agreement, Mr. Northernfelt entered into a restrictive covenant or restrictive clause by which he could not engage in the trade of manufacturing guns, explosive or ammunition, or engage in any competing business for a period of 25 years anywhere in the world. So there were two clauses. Number one, that he could not engage in the trade of manufacturing guns, explosive or ammunition. And second clause was that and he could not engage in any competing business for a period of 25 years anywhere in the world. So there were two clauses of the agreement. So in breach of this agreement, Mr. Northernfelt later entered into an agreement with another gun company and hence the suit was filed. It was held that the provision prohibiting Northernfelt from making guns or ammunition was a reasonable one, and the provision banning or prohibiting banning competition in any way, anywhere in the world was an unreasonable, and therefore it was a total restraint of trade, and therefore it was invalid. Apart from the exceptions which we are going to discuss below, all agreements in restraint of trade are void. Let us discuss the exceptions. The exceptions are: Section 27 of the Act mentions exception validating restraint of trade, that is sale of goodwill. Another exception is found in the Partnership Act. So under Section 27, these mentions the exception, and these exception, if it fall under exceptional case, in such case agreement in restraint of trade will be valid. So one who says, so let us discuss first one, the sale of goodwill. One who sells the goodwill of a business may agree with the buyer to refrain from carrying on a similar business within the specified local limit, so long as the buyer carries on a like business, provided that such limit appear to the court to be reasonable, regard being had to the nature of the business. So in India, it may be noted restraint is valid if it falls within any statutory exception. So the first exception is sale of goodwill. The seller of the goodwill of the business can be restrained from carrying on a similar business within specified limit, provided the restraint is reasonable. So there are certain conditions that make a restraint on trade during a sale of goodwill valid. These are: number one, the seller can be restrained only from carrying out a similar business. Another, the restraint can be applied only to certain local limits, and the limits or restraint should appear to be reasonable. So these are the conditions. Then and then only such restraint will be valid. If a person sells his business along with the goodwill, then the buyer can ask the seller to refrain from practicing the same business at a local limit. So, if according to such an agreement, as long as the buyer carries on such a business, the agreement to restrain the trade of the seller will be valid. For example, X buys from Y the goodwill of the business of plying ferry boats across certain ghats on a river, and Y promises not to ply his boats at those ghats. So the restraint is valid. Here, another case we can discuss here. The plaintiff was the owner of a fleet of buses that used to ply between Pune and Mahabaleshwar. The defendant also had a similar business in the same area. To avoid competition, the plaintiff bought the defendant's business along with the goodwill, and by contract made him agree not to open a similar business in the area for 3 years. The defendant did not comply and started his own business in the same area. It was held that by the court the agreement was valid as it fell within the exception to section 27, because here the buyer had purchased a goodwill and therefore he can restrict the seller from carrying on the same business, and therefore the restriction was valid. But say a lawyer sells his legal practice to B along with the goodwill, and A agrees never to practice as a lawyer anywhere in the state for the next 20 years. This is not valid agreement since the terms are not the terms are completely unreasonable and it is not in the interest of party and therefore it is not valid. Second exception, which is in the Partnership Act, another exception to the rule of limitation on agreements in restraint of trade is provided under the Partnership Act 1932. The Act lays down three exceptions. These are number one, an agreement with a partner of the firm not to carry out his own business so long as he or she is a partner in the said firm will be valid under section 11 section 11 subsection 2 of the Partnership Act. Another number 2, an agreement between partners not to engage in a similar business as that of the said firm within specified territorial and time limit period of restraint, that is under section 36 subsection 2. And number 3, partner may, upon or in anticipation of dissolving the firm, the partner may come to an agreement in restraint of carrying out a similar business within specified territorial and time limit so long as this restraint is reasonable. Similarly, if an outgoing partner can enter into such a restraint of a trade agreement with the partnership firm, also a contract between partners not to carry out any competing business during the continuance of a partnership is also valid contract. It may be noted that the above agreement is that the term of such agreement have to be reasonable. Such reasonable terms are not defined under the Act and are and to be judged according to each unique situation and circumstances. It may differ from case to case. So let us discuss illustration Daulat Ram versus Dharamchand. In this case, two similar business owners in partnership came to an agreement that only one of their factories would work at a time and the profit will be shared between them. This restraint was held to be valid. Another illustration, A who employs B as his assistant for 3 years. For this duration of 3 years, B agrees not to practice medicine anywhere else. So this is a valid agreement even though it is in restraint of trade. Third exception is trade agreements or trade combinations. Traders and manufacturers in the same line of business normally form associations to regulate business or fix prices. So agreement to form combinations or trade association to fix rates and to divide profits in certain manner is not in restraint of trade or opposed to public policy. Opposed to public policy. They bring about standardized goods, fixed price and eliminate ruinous competition. Similarly, pool or trade combinations. Similarly, Similarly, pool or trade combinations between group of manufacturers or traders are valid agreements, provided the object of an agreement is to promote welfare of the parties themselves by regulating their trade. An agreement between ice manufacturers not to sell ice below stated price and to divide profits in a certain proportion is not valid under section 27. Such agreements are neither in restraint of trade or neither nor opposed to public policy, are not void. But an agreement, object of which is to create a monopoly, is void as being opposed to public policy. For example, it was agreed among members of the Society of Hop Growers. Hops are flowers and they usually use as an agent to make beer, that make beer flavor, bitter flavor, and also use in beverages and herbal medicine. So it was agreed among members of the Society of Hop Growers that each member would deliver hop grown by him to the society, which would market the hops and divide the profits among the members. So hence the agreement was valid. So the trade combinations or trade agreements are valid if it is not opposed to public policy and if it is in the interest and welfare of the people. Number 4, sale of agents agreement. A manufacturer or producer may appoint a sole agent or distributor and the latter may agree in turn not to deal with or solicit the goods of any other manufacturer. Such restraint, of course, in trade is binding. Thus, an agreement by a person to sell all the salt manufactured by him to a firm for 5 years is outside the purview of section 27 and therefore valid. Number 5, service contracts. Sometime an employee by the terms of his service agreement, it is prevented from accepting number 1 any other engagement during his employment, and number 2 a similar agreement after the termination of his service. So as a regard the former, it is valid. It is not interested of trade if it is to operate while the employee is contractually bound to serve his employer. For example, a doctor employed in a hospital may be debarred from private practice. Such negative stipulation Such negative stipulations in service contracts are not considered to be in restraint of trade and are therefore perfectly valid. Example of service contract. The article clerk of a solicitor stipulated that he would not practice as a solicitor within 7 miles of a certain place after he became qualified as a solicitor and left his previous employment. The agreement was held to be valid. Similarly, if a restraint is intended to protect an employer against an employee making use of trade secrets, learned by him in the course of his employment, the restraint is valid provided it is not for any other purpose also. For example, a servant copied the names and the addresses of his employer's customers. A servant copied the names and addresses of his employer's customer for the use after he left his employment. He should be restrained from using the list. So all agreements in restraint of trade are void, but if it is under statutory exception wherein restraint in trade will be valid. Number 4 exception is sale of agents agreement. A manufacturer or producer may appoint a sole agent or distributor, and the latter may agree in turn not to deal with or solicit the goods of any other manufacturer. Such restraint of course in trade is binding. Thus, an agreement by a person to sell all the salt manufactured by him to a firm for 5 years is outside the purview of Section 27 and therefore valid. Another exception is service contracts. Sometime an employee, by the terms of his service agreements, is prevented from accepting number 1 any other engagement during his employment, and number 2 similar agreement after the termination of his service. So as regards to the former, it is valid and is not in restraint of trade if it is to operate while the employee is contractually bound to serve his employer. For example, a doctor employed in a hospital may be debarred from private practice. Such negative stipulation in service contract are not considered to be in restraint of trade and are therefore perfectly valid. So let us discuss the examples. The article clerk of a solicitor stipulated that he would not practice as a solicitor within 7 miles of a certain place after he became qualified as a solicitor and left his previous employment. The agreement was held to be valid. Similarly, if a restraint is intended to protect an employer against an employee making use of trade secrets learned by him in the course of his employment, the agreement is valid, provided it is not for any other purpose also. Example, a servant copied the names and addresses of the employer's customers for use after he left his employment. He should be restrained from using the list. So all agreements in restraint of trade are void, but if it is under statutory exceptions wherein restraint in trade will be valid. So if it falls under statutory exceptions, then and then only agreement in restraint of trade will be valid. Otherwise, all agreements in restraint of trade are valid, void.